oh yes, oh yes. This Honorable Court of the Criminal Appeals of the State of Tennessee is now in session. God save the United States, the State of Tennessee, and this Honorable Court. You may be seated.
Good morning. Welcome to the April docket. We're only going to have 5 minutes of arguments each today. So. All right, as all of you know, each side has 20 minutes to argue. If the appellant wants rebuttal time, please let us know at the beginning. I'd like to introduce the panel. To my right, your left, is Judge Tom Greenholz from Chattanooga. And to my left, your right, is Judge Kyle Hickson from Knoxville. And I'm Bobby Holloway from Columbia. Any preliminary matters, Madam Clerk?
No, Your Honor.
All right, call the first case, please.
State of Tennessee versus Valerie Garrett.
Good morning, Your Honors.
Good morning.
Morning.
My name's Hal Dorsey. I'm a criminal defense lawyer here in West Tennessee. What we appealed here is the trial court's ruling on a motion to suppress. The entire basis for this traffic stop, well, I guess I ought to give you some background. This is a DUI case where Miss Garrett was stopped for violating traffic laws, and we say that really didn't happen. The traffic stop is on video. The video is part of the record. The basis.
Let me mention one thing. Typically,
Yes.
we have only read the briefs.
Okay.
But after we read the briefs in this case, we realized that the video was going to be of critical importance. So I think all three of us have watched the video.
Okay.
Okay,
Yes.
just for your information.
It's our position that the crossing of the yellow line, we say that just didn't happen. I mean, we not no offense to anybody, but we just say she didn't touch the yellow line. Yes, she got close to it, but she didn't touch it. She didn't go over it, and we also say that was the basis for the stop. We have to admit that when she made the turn from Hollywood on to North Parkway, that she crossed the segmented line. I mean, we have to admit that. I think that happened, but it's our position that there wasn't any way for her to make that turn. The way the intersection's built, the way a lot of these intersections are built, and without crossing that segmented line.
This may not be in the record, but I was wondering, was she planning to turn left where she did turn left, or did she turn, because it's almost crosses the stripe line and she's back in the stripe line to turn left after the blue lights come on? Do you know, is that in the record?
I'm not sure it's in the record. I think I argued it in my brief, and I think I may have thought to myself later, I hope that's in the record. She was turning left, and it appears that she was going to make another left right there after she made the first left-hand turn, and we sort of say that's the reason why she crossed the segmented line. And we're just saying all in all that there was just no reasonable suspicion, A, that she was driving under the influence, and B, that she had even, committed a traffic violation. There's going to be some irregularity in a little bit in everybody's driving. And we say that it just didn't rise to the level of reasonable suspicion or probable cause to stop her.
So if there were no video in the case and it were just the officer's testimony and the trial court credited the officer's testimony, would there be reasonable suspicion to support the stop? I mean, there would be, wouldn't there?
I suspect so, yes, sir.
All right, so the real basis of the argument here is that as a matter of law, the video itself contradicts the officer's testimony such that the court had no basis to make a finding that the line had been crossed.
That's absolutely our position, yes, sir.
Okay. Is it possible in some cases, though, that the human eye can detect things that may not appear on video? So for example, oftentimes, and maybe with this video too, maybe not, a video may have a distorted perception. I mean, we're at night, we've got, the lighting conditions are there, you can see the cars. But is it possible sometimes that the human eye can detect things that aren't showing up clearly on video?
Yes, sir, of course that's possible, but it's our position that in this case, that you had a fairly, I thought you had a fairly good look at what was going on out there, and I just didn't see any traffic violations.
Sure, okay. Well, so what do we make, though, of the trial court's finding then ultimately that based upon the video, based upon the officer's testimony, the court makes a specific finding that she crosses the line at 26 seconds and at 52 seconds?
I just think the video clearly contradicts that finding, and I think it's obvious that didn't happen. And while I have a great amount of respect for the judge, I just disagree with him, you know.
If we were to find that it isn't clear to us whether she crosses the line or not, meaning that it appears that maybe she did, it appears that maybe she didn't, are we in that circumstance where we can't definitively make a call that she did not? Must we defer then to the trial court's finding of fact?
We would just take the position that the burden of proof is on the state.
Sure. On appeal, though, is it a little different? Because now we have factual findings that the court has to defer to?
Oh, yes, sir.
Yeah.
It would be.
Okay. All right, but the position is that as a matter of law, the video shows that the line crossing didn't occur.
That's our position, yes, sir.
Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments because the trial court properly denied the defendant's motion to suppress, where the officer had probable cause or at a minimum reasonable suspicion to initiate a traffic stop. So I think the facts are pretty well agreed upon, and as Judge Holloway, as you noted, the video sort of the video shows what happened, but the state's I think
Does it clearly show what happened?
I don't. I think to your point, Judge Greenholtz, what we have here is the police officer was in the right-hand lane and the defendant was in the left-hand lane. At the time markers that the trial court points to, it sure looks like the defendant crosses the line. I don't think that there is clear and convincing proof either way, honestly. But to your question, to my friend on the other side, when that is the case, when it is not clear and unequivocal or the evidence doesn't preponderate against the trial court's factual finding, this court is bound by them.
And this is not a Benet situation, right, where we're only relying upon the video. We have video plus credited officer's testimony.
Exactly. Here, the officer testified that I saw the defendant cross this yellow line twice. The trial court accredited that and then said the video corroborates that. And if anything, the video doesn't contradict it.
I'm sorry, Judge Holloway.
Is it a violation of the rules of road and probable cause if a driver gets on without crossing over the center line?
My recollection of Davidson is that if you touch the line but don't cross it, it is not a violation. Again, what we have here is the officer testifying that she actually crossed the line into it.
And so crossing it, not touching it, means you go all the way across where your left, on this situation, your left tire is not touching the line at all on the other side of the lane.
I wouldn't go that far. I would say if your left tire is touching black asphalt across the line, that would arguably be crossing the line. But honestly, if this court doesn't necessarily want to get into those semantics or address the two crossings that may or may not have happened, again, we have accredited testimony that they did, excuse me, and the video doesn't contradict it. Excuse me, Your Honors.
Well, I just, when I watched that video, my thoughts were if I was grading her driving on a 4-point scale, I'd give her about a 3.5, maybe a 3.6. I mean, this is minimum crossing the line if she crossed the line, in my opinion. You know, I can't see where she crossed it. She drives close to it the entire way. And she clearly gets on it on a couple occasions.
I understand that, Your Honors, and if Your Honor feels, uncertain about finding that there was probable cause or reasonable suspicion based on those two violations. What we have here is that the defendant admits and concedes that she at base violated it on her left-hand turn. She went into she crossed the yellow lines where there are segmented lines saying you cannot drive. And to her argument that it was impossible to do otherwise, the video just shows that that's not true. When she was turning left into a normal perpendicular, four-way street, she could have stayed in the left-hand lane and made the turn from that left-hand lane. And at minimum, I was thinking about this, and even if she couldn't do that, at minimum, the officer had reasonable suspicion to say, why are you getting into this lane? To pull her over, initiate a traffic stop, to say, I think you violated this by going into this segmented line section. And that's the only basis of the appeal, is whether there was reasonable suspicion at a minimum to initiate a traffic stop.
Of course, that third basis, I'm sorry,
No, go ahead.
That third basis was not a basis that the trial court relied upon. I don't even know that it was a basis that the officer necessarily relied upon. So, in essence, I think you're arguing that we should affirm, or we could affirm on a basis that the trial court made no findings on?
You certainly can. Again, we're just looking at the propriety of the order. I will say the officer did rely on it. He explicitly commented that I didn't put it in my report because I already had 2 other violations. I didn't want to, sort of load it up, but said part of the reason I did pull her over was because she violated that third time. And again, when the video clearly shows that the defendant concedes that she got into that lane, state's position is that is at minimum reasonable suspicion to initiate a traffic stop to investigate why she got in there, if not probable cause of just a violation in and of itself. So honestly, this court can sort of pick 2 or 3 different bases why there was a valid basis to initiate the stop, but ultimately the trial court properly denied suppression where there was a valid basis.
Just to clarify from the record, was the trial court's holding based upon, forgive me, the statutory citations, 55-8-123 as in Smith or 55-8-115 as in Davis? What was the basis of the trial court's finding?
I believe the court, the officer said it was a violation of 55-8-123, and I believe the court also said that the record would speak more accurately. But even if that wasn't the basis, this court can find that was still a violation.
Okay.
If there are no further questions, we ask that you affirm the judgment. Thank you.
Mr. Dorsey, any rebuttal?
I don't have any rebuttal. If y'all have more questions, I'd be happy to answer.
I've got a comment.
Yes,
You need to teach a seminar about how to avoid certified questions and do it the way you did. That's the way,
Yeah, I'll echo that as well.
just have a bench trial and go through the suppression. That's a smart way to do it from my point of view.
Thank you, I appreciate it.
Yep, thank you. Call the next case, please.
Harry Raymond Coleman Jr. versus State